Good evening, everyone. I am Stella Maria Datuin. We are now done with the chapter 1 and we will go to the chapter 2, which is entitled Obligation of the Partners. But before anything else, let's discuss about the agenda or what this presentation is all about. The first one is the definition of partner, followed by the kinds of partners. Next one is the sample problem, and last the conclusion. The definition of partner. I have gathered different definition of partners from different works. The first one is the definition from a dictionary. One person associated with another, especially in action. Meaning these are person or these are the people who collab or combine in order to achieve specific action. For example, given by the dictionary is the an associate or the colleague of an organization or of a group. The second definition is that partner, it could be people who agree to cooperate in order to advance their common mutual interests. This could be expressed in a win-win negotiation, meaning you sacrifice, I sacrifice, we build mutual respect and understanding while getting the results that both of us wanted to have. So, the next definition is a partner is a member in a partnership, an entity which both the profits and losses of business or other venture are shared between all members. This means that a partner in a partnership is that once a partner contribute the money, when the entity earns and make a profit, it will disseminate to all members depending on the capital they share on the entity. For example, it could be 50% to 50%, 60, 40, or 70 to 30%. It depends upon on the partners. And it also occurs when the entity make or have losses. It's also disseminate to all members. The last is partners. Based on what I have researched, the minimum partner in a partnership is 2 and the maximum of 100, but it depends upon on the nature of the business. If the business is a banking, the maximum only is 10 person. Next, let's go to the kinds of partner. There are different kinds of partners in a partnership, but it classifies in a different perspective. The first one is the as to contribution. Partner. A partner could be a capitalist, industrial, or capitalist industrial partner. When capitalist partner, this means that the partner who contribute money or property or both money and property to a common fund. While the industrial partners, these are the partners who contribute knowledge or personal service to the entity or to a common fund. While the capitalist industrial partners, these are the people who contribute money or property and industry or the combination of the three money, property, and industry. Um, it's it is the contribution to the business. The three. The next one is to the liability. As to the liability, a partner could be a general partners and a limited partners. General partners, meaning they are the one who is liable to the extent of his separate property after all the assets of the partnership are exhausted, meaning the third person can go to them in order to fulfill their obligation or the obligation of the partnership. While the limited partners, these are the people who is liable only to the extent of their capital contribution, and the third person cannot go to them in able to fulfill the obligation. And according to what I have researched, limited partners cannot only contribute service or industry industry only. They should contribute aside from industry is the money or the property. The next one is partners as to management. A partner, it could be either managing partner, silent partners, and liquidating partners. A managing partners, these are the one whom the partners are appointed as a manager of the partnership. They are the one who takes in charge to the affairs of the partnership. From the word itself, managing partners, they actively manage the affairs or uh, the event or the what's going on in the business. The next one is the silent partners. These are the partners who does not take active part in the business but known as a partner, and they share in profits or losses. The next one is the liquidating partners. Liquidating partners, they are the one who is designated in to take in charge in a winding up or to wind up or settle the affairs of the partnership after the dissolution. Another kinds of partners according to third person. As a third person, partners could be ostensible partners, secret partners, and dormant partners. Ostensible partners meaning they are the partners who take in charge in a active part or managing the business, and at the same time, they are known as the partner by the public. The next one is the secret partners. From the word itself, secret. Those connection doesn't known by the public, but they take charge to the active part of the managing business. The third one is the dormant partners. It is a combination of both silence and secret. So meaning they do not take in charge or they do not take active part or the managing of the business, and at the same time they are known as the partner of the public. The next partner is as to membership. Partners as to membership could be either a real partners and partners by stupel. Real partners meaning they are partners in a legal partnership, or they are technically part of the partnership. While the partners by estopel, they are not really partner but represent themselves as a partner, meaning technically and legally they are not part of the partnership but they represent them as a member. And if that's so, they are liable to the obligation of the general partner as the assumption that they actual partner of the firm. The next partner is as to the contribution of the business affairs after dissolution. It could be continuing partner and the discontinuing partner. The continuing partner, they are the one or those who continue the partnership after the dissolution. The discontinuing discontinuing partners, it is a contrast to the continuing partners, because when the continuing partners are the one who continue the partners, the discontinuing partners, they are the one who do not continue the partnership after the dissolution. Another partners as to the nature of membership, it could be original partners, incoming partners, and retiring partners. Original partners meaning they are the one or those who are members of the partners from the time of its constitution or since the beginning of the formation of the partnership. They are already partners or they are already member. While the incoming partners, they are the one who became partner or became a member after the establishment. And last, the retiring partners, those who withdraw or withdrawn from the partnership, or from the word itself, retiring partnership, retired partnership, or retired partners rather. The next one is partners as the state of survivorship. It could be surviving partners and the deceased partners. So, surviving partners meaning they are the one or those who continue the partnership after its dissolution by the reason of the death of a partner. While the deceased partner, they are the one who died while being a member of the partnership. From the word of deceased, so who died while being the member. The next partner is as to the effect of expulsion. So, it could be expelled partners and the expelling partners. Expelled partners, those who are expelled from the partnership by the other partner for a valid cause. Meaning, if they did something wrong that could affect the partnership, so the partner has the rights to expel the partners. The next one is the expelling partners. They are the one who caused the expulsion of a partner for a valid cause. So the expelled and the expelling the one who make the expulsion of the another partner. And the last one, partners as to the value of the contribution. It could be majority partners and the nominal partners. Majority partners, from the word itself, majority represents majority interest, and the nominal partners represents minority interest. Or the majority, they are um, control the they control more rather than the nominal partners. The nominal partners, the minority, and the majority partners are the majority. As to the third topic of the presentation, I have here the sample problem. It is the section 1 obligation of the partners among themselves. It is a sample problem given by the book and I just use it. So Y Corporation is a general partnership duly registered to the law of the Philippines who purchased a motor vehicle on installment to X Incorporation with a promissory note of 9,440 pesos in 12 equal monthly installment of 786.63 pesos. The first payment was made on May 22, 1961, and the second payment or the followed payment is the 22nd day of every month until fully paid, with the condition that failure to pay any of the said installment would render the whole unpaid balance immediately and demandable. So having failed to receive the installment due, X Incorporation sued Y Corporation for the unpaid balance amounting to 7,119 pesos. So Y Corporation failed to pay its obligation. So X Incorporation make a complaint against the Y Corporation. A, B, C, D, and E as a co-defendants, they represent themselves as co-dependents and at the same time as the general partners of the partnership. But in a motion, the complaint subsequently dismissed because first there were 5 general partners, and to the creation of the obligation or the promissory note obligation is a prorata, meaning refers to a proportional allocation. This means revenues, expenses, assets, liabilities, or other items are proportionally allocated among participants. And I think it is the solidary obligation, or meaning every one or each of the partners has are bound to render the obligation. So meaning the A, B, C, D, and E has only one fifth of the obligation to X Incorporation, and both of them are liable, or all of them are liable to the obligation. So before I end this topic, it is the conclusion. According to Meadows 2016, partnership can be a successful way to run business, but it can also destroy Friendship. Picking the right partner is a vital step in the strategic planning of a business. All partners should enter into general contract with all expectations clearly stated in writing for their own perfections, as well as the protection of the partners. So, uh, yun, it's basically the quotation wanted to tell us that if we want to make or create a partnership, we must the contract is properly stated or well written, so that the conflict or the the conflict or the misunderstanding or misinterpret will never occur in the partnership. Because it because if there is a conflict, it could not only destroy the partnership or the business, could also destroy the friendship of the partners. And that would be all. Thank you very much.